Workmen Compensation Act 1923. So under this act covers the whole of India and applies to any person who is employed otherwise than in a clerical capacity in the railways. The employees, those who are working in railways, factories, mines, plantations, mechanically propelled vehicles, loading and unloading work on a ship, construction works, maintenance and repairs of roads, bridges, etc., electricity generation, cinemas, cinema halls, then catching or training of wild elephants, circus, and other hazardous occupations and employments specified in Schedule 2 to the Act. So, whoever is employed in all these establishments, those are covered under this Act. So, this is under Schedule 2 to this Act. And under subsection 3 of section 2 of the Act, the state governments are empowered to extend the scope of the Act to any class of persons whose occupations are considered hazardous after giving 3 months notice in the official gazette. So those will also be included here under this Act. So the employees or the workers, those who are engaged in any kind of occupations which are considered to be hazardous, will be covered under this Act. And the next one is the Act, however, does not apply to members serving in the armed forces of the Indian Union. So, and the employees covered under the provisions of the Employee State Insurance Act 1948, as disablement and dependence benefits are available under this Act, they are not covered under this Act. So here under Employees Compensation Act, the employees, those who are working in any factory or railways or whatever I have discussed now here, so all are covered under this Act, and the employee who are serving in the armed forces of the Indian Union will not be covered under this Act. So they will be covered under the Employee State Insurance Act. So this is the main objective of Employees Compensation Act 1923. It provides for payment of compensation to the employees and their dependents. So in the forthcoming slides, we'll be discussing about who are called employees and who are considered to be dependents. So here payment of compensation is to be given to the employees and their dependents. So this is in the case of injury by industrial accidents. So they'll be getting this compensation amount, including certain occupational diseases. So due to the occupation, if they are affected with some diseases, then those for that reasons also they'll be compensated. And arising out of and in the course of employment resulting in death or disablement, so for those reasons also they will be covered under this Employees Compensation Act 1923. So this is basically the structure of Employees Compensation Act. So this act is divided or it has 36 sections which are divided into 4 parts. So which are 4 schedules. So the first schedule is list of injuries, and the part 1 is total disablement. So in case of total disablement, what is the injuries that are covered under Schedule 1? And in the case of partial disablement, so that is coming under part 2 under Schedule 1. So Schedule 1 deals with list of injuries which paves way to the total disablement or the partial disablement. And the Schedule 2 is full of list of persons who are included in the definition of employees. So here Schedule 2, all the definitions are listed. So under Schedule 2, we can get the definition of employees and who are called as employees. And schedule 3 will be basically list of occupational diseases covered. And schedule 4 is full of factors for working out lump sum equivalent of compensation amount in case of permanent disablement and death. So these are the 4 important schedules that are covered under this Employees Compensation Act. So here, Employees Compensation Act is called as Workmen's Compensation Act, but in a recent amendment, this has been changed to the Employees Compensation Act. So this aims to provide workmen and their dependents some relief in case of accidents arising out of in the course of employment. So that is the basic key term here. So during the course of employment, they are covered under this Compensation Act. So and causing either death or disablement of workmen. So here this is under section 2. These are the definitions covered under section 2. One is commissioner, dependent, who is a dependent, employer, disablement, wages, and workmen. So we'll see who is commissioner, who are called as dependent, who are covered under this dependent, and what are the liabilities of the employer. Under disablement, what are the different types of disablement, and the wages, workmen, all the definitions. So here who is dependent? So this is under section 2(1)(d). Dependent means any of the following relatives of a deceased workman. So here a widow. So a widow, a minor, she might be a minor legitimate or adopted son, an unmarried legitimate or adopted daughter, or a widowed mother. So these are covered under the first definition. So a dependent could be any of these: a widow or a minor legitimate or adopted son, and unmarried legitimate or adopted daughter, or a widowed mother. The second one is if wholly dependent on the earnings of the workman at the time of his death, or he could be his son or a daughter who has attained the age of 18 years and who is infirm. And any of the following were wholly or partly dependent on the workman at the time of his death. So these people are considered to be dependent. And she could be a widower or a parent other than a widowed mother, a minor illegitimate son, an unmarried illegitimate daughter, or a daughter legitimate or illegitimate, or adopted if married, and a minor or if widowed and minor. So these are all the subcategories under uh, the under dependent. And a minor brother or an unmarried sister or a widowed sister if a minor, a widowed daughter-in-law, a minor child of predeceased son and daughter where no parent of the child is alive, and a paternal grandparent if not the parent of the workman is alive. So all these persons are considered to be dependents for the deceased person. So employer, according to section 2(1)(e), the employer includes any person or body of persons, whether incorporated or not. Any managing agent of an employer, so he is also considered to be an employer. The legal representative of a deceased employer, or a person to whom services of a workman are temporarily lent or let on hire. So this is the definition for this employer. And according to section 2(1)(n), workman refers to any person who is a railway servant. So as defined in this clause, according to Railways Act 1989, not permanently employed in any administrative district or subdivisional office of a railway, and not employed in any such capacity as specified in Schedule 2. So he is referred to as workman. And he can be a master, a seaman, or other member of the crew of a ship. So he is also called as workman. It does not include a person whose employment is of casual nature. So he should be a permanent employee. That is another thing to be noted here. And a captain or other member of the crew on an aircraft, a person recruited as driver, helper, machinist, mechanic, cleaner, or in any other capacity in connection with a motor vehicle, or a person recruited for work abroad by company, as is mentioned in Schedule 2. All these are persons who are called as workmen. So, person to be treated as workmen, they must be a contract. They must have a contract of employment with the organization. There must be a relationship of master and servant between the employer and the employee. The employment is for the purposes of employers. Only then he is treated as workman. So this employer's liability, this is according to section 3 of the act. So as per section 1 of the act, the following conditions should be necessarily met. So it should be satisfied in order to qualify for compensation. So here he must be a workman within the of this act. So only then he is eligible to get compensation. Or second case, personal injury must have been caused by accident. So that is another condition, personal injury, and the injury must have been caused by accident. So it is not because of a planned one, right? So the injury must have been caused by accident. So the accident must have arisen out of and in the course of employment. So that is another important thing. So during the course of employment, if anything happens, and it should be an accident, the injury caused by the accident must have resulted in the workman's death, or permanent total disablement, or temporary disablement. So these are the cases in the employers are liable to pay the compensation under section 3 of this act. And accident arising out of and in the course of his employment, the employer is liable to pay compensation in case of personal injury also, not only the disablement or death. So in case of personal injury and occupational disease also, the employer is liable to pay compensation. And the next one is personal injury includes physical or mental injury, strain or shock caused by excitement. So all these are also covered under this act. The next one is incidental to his employment and injured, then arises out of employment. So here in like any injury could be held to have arisen out of employment if it is established that it must have resulted from some risk incidental to the duties of the service or inherent in the nature of employment. So some employment will obviously have some inherent nature of risk. So say for example, if he is employed in a company which is dealing with radiations or IR therapy and something like that, then it is obviously there is some kind of inherent risk in that kind of employment. So here it must have resulted from some risk incidental to the duties of the service or inherent in the nature of the employment. So in this case also, the like what this kind of thing is also included here in this act. So at the time of injury, the worker must have been engaged in the business of the employer. and must not be doing something for his personal advantages. So here he should be in his duty. So he should be performing his duty. So only when, if he is injured, he is eligible to get the compensation. So this is another important thing which comes under the Employees Compensation Act, which is called as Doctrine of Notional Extension of Employment. So here, what this means is when the employer provides the employee with a particular conveyance to and from the place of employment, the employee is regarded as in the course employment, even though he has not reached or has left his employer's premises. So what this means is, say for example, when there is, so here the notional extension of employer's premises will be when there is a causal connection between the accident and the place where the employee is working. So say for example, he is actually traveling, he has to travel through a boat so as to reach his workplace. So during their travel time, while traveling in the boat, if anything is caused and the employee or the workman is injured or he lost his life, so in that case also he is eligible to get this compensation. So that is called as doctrine of notional extension of employment. So there should be a causal connection between the accident and the place where the employee is working. And the compensation is payable for the disability or death of the person according to the Employees Compensation Act. So that is called as doctrine of notional extension of employment. So here, this is the meaning for disablement. So disablement means reduction in earning capacity. So it may be partial or total disablement. So in case if he lost his hand, one hand, and still he can able to do his duty. So in that case, what is the settlement given to him is partial disablement. That is considered to be a partial disablement. And temporary partial disablement, permanent partial disablement, these are the two types which comes under the partial disablement. And there could be total disablement also, and temporary disablement, permanent disablement. So these are the different types of disablements that this act covers. So here, this is the meaning for temporary partial disablement. So this means that which like anything which reduces the earning capacity of the workman in the employment in which he was engaged at the time of accident. So that is called as temporary partial disablement. So anything which reduces the earning capacity of the workman. So that is temporary partial. And what is permanent partial disablement? It means that this which reduces for all time the earning capacity of a workman in every employment in which he was capable of undertaking at the time. So wherever he goes, he couldn't do his full performance due to his disablement. Permanent partial disablement. So like always reduces for all time earning capacity of a workman. Disablement means whether of a temporary or permanent nature, which incapacitates a workman for all work which he was capable of performing at the time of accident. So he couldn't do anything. So the totally when his hand is lost. So in that case, it is called as total disablement. So this is how the calculation of compensation is made under this act. So these are some of the formulas that are used to calculate compensation. So here the first case, in the case of death, the amount of compensation is calculated based on 50% of monthly wages into what is the relevant factor considered for that particular issue, divided by rupees 80,000. So whichever is more, then that is considered to be given as amount of compensation. So this is in the case of death. And the second one is permanent total disablement. So here the amount of compensation is calculated with the help of this formula: 60% of monthly wages into relevant factor divided by rupees 90, sorry, uh, or 90,000 rupees. It is not divided, sorry. So this is 50% of monthly wages into relevant factor or 80,000. Whichever is more, then that is considered to be the amount of compensation in the case of death. Or permanent total disablement. So 60% of monthly wages into relevant factor or rupees 90,000, whichever is more, this is considered as compensation. Here, permanent partial disablement, the same thing, 60% of monthly wages into, there is no kind of amount which is specified and disablement, 5% of monthly wages. So this is the calculation of compensation according to this act. And here, in some cases, the employers are not liable to pay the compensation to the employees or the workmen. So here, the injury does not result in the disablement for a period exceeding 3 days. So in this case, the employer is not liable to pay or to pay for any compensation. So if he is not, if it is not resulting in a disablement, right? And the next one is the injury results in death or permanent total disability due to the worker was at the time of accident under the influence of drink or drugs, right? So this is any injury which are caused due to his own uh, act of drinking and using drugs. So in that case, if anything happens, so that is, in that case, the employer is not liable. And the worker willfully disobeyed any order expressly given for ensuring safety, right? So if he is not following any kind of safety standards and willfully he is disobeying any order, so in that case employer is not liable. And the next one is the worker willfully removed any safety devices which he knew would harm him, so in that case also the employer is not liable. So these are the situations in which the employer is not liable to pay the compensation. So this is another new term which is contractual employment. This is also another thing which we can see in industries and factories. So this is under section 12(1). So if any employer takes the help of contractor in order to engage some workmen. So here in this case, workmen who are injured or entitled to compensation from the principal. So here when the principal is held liable for compensation, he shall be entitled to be indemnified by the contractor. So here, if any worker who is working under a contractor, one who is not having direct relationship with the organization, then in this case, the principal is held liable for compensation and he shall be entitled to be indemnified by the contractor and not by the organization. So this is in terms of contractual employment. So here in this case, only the contractor is liable for to dispense the compensation amount. So this is another one which is contracting out. So here any contract whereby a worker relinquishes in the right of compensation from the employer for personal injury arising out of and in the course of employment will be null and void. So here the employer is not having any such duty to dispense the amount to the employer or the workmen, those who are working under contract. So here any worker who are working under a contractor, then contractor is only the person who is liable for the employee. So here the employer can't use it as a defense. So this is contracting out. And here under section 19 to 31, so this actually covers who is called as a commissioner and what is his role and who will be appointing the commissioner. So here this is authorities under the act, which covers the sections 19 to 31. So these sections provides for appointment of commissioners for the enforcement of provisions of the act. So he is the responsible person to monitor whether all these provisions of the act by every company is being followed, right? So these sections provides for the appointment of commissioners for the enforcement of provisions of the act, and section 20 authorizes the state government to appoint commissioners under the act. So this is all up to all with regard to the employees or the workmen compensation act, or which is now employees compensation act. Thank you.